Midori, mayong hapon. Salamat bay, salamat. Buwat ako sa kong klase. Pwede na nabuhat bay. Emerlita. Good eve. Salamat, salamat. Si Emerlita Hamor. Salamat bro Adidos. Salamat Bay Cyrus. Merlita, maraming salamat. Salamat Inday. Okay lang bro, okay lang bro. Salamat. Silent sana ako kaya na ko itawagan. Lapit na kuya. Kulat lang ko. Oras. Salamat tayo, salamat. Yo. Oh, alas 6. Alas 6, alas 7. Hanggang alas 9. Ano?
Natakpan na talaga ako.
Reggie Flores Remix.
Salamat. Gaya mas akong klase. Ay.
Good evening, guys. There is already a quorum in the class, so let's begin. Prayers, please.
Okay, let us... sige, sige.
And Father, the Son, and Holy Spirit. Lord Jesus, as we start the year with a refreshed soul and a grateful heart, may continue to bless us with an open mind as we embark onto another year of learning. May you strengthen our conviction to finish what we all so eagerly started. Bless everyone here, my classmates and professors, as together we continue our educational journey onto the realm of the law. This we ask in the mighty name of Jesus our Lord.
Amen. Nag-amen na din yung manok. Okay. Thank you. Okay. Let's begin. Okay. Mr. Ravi. Hello, sir. Good evening po. Good evening. How are you po? Mabuti naman. Ready na ako sa exam. My game face. With my game face. And actually, it's a bad face. Well, kayo, ready na? Yes, sir. Yes. I do. Okay, let's see whether you're ready or not. Nangkit kasi ako kay Mr. Magallanes at saka kay Major Kaingbon eh. Oh, pati si Mr. Bale. Anyway, let's begin, Mr. Maradi. Let's see whether you're ready for the exam. Okay? Can you give us the purpose of of a torrent's title as enunciated or as declared by Justice Johnson in the case of Legarda versus Salibi?
I find it a case versus. Sorry.
Pardon? Pardon? You were trapped.
Yes, sir. I just find the case. I just remember it.
Okay.
Sorry, sir.
Mr. Miss Del Perut, excuse me, Mr. Maladi. There's some problem with your camera?
My camera, sir.
No, Miss Del Perut.
Yes po, Sir Joey. May I be allowed to turn
Sige, pa-off muna. Medyo nakaka-distract
Opo, sorry,
pa-distract.
sir.
Pakiayos muna po.
Opo.
Continue, Mr. Maladi.
So what case you said, sir? I forgot.
Legarda versus Salibi.
This case, if I for installation regarding that. I think I read this one.
Pardon? You haven't read?
I think I read it. I forgot the title. It was in section 6, I think. Immediately available argument.
You probably revisiting the question, you may be reminded of the case. Okay? It is in that case that Justice Johnson declared the real purpose of a torrent's title. So what is the purpose, the real purpose of a torrent's title declared by then Justice Johnson in the 1915 case of Legarda versus Salibi?
It was about what I remember in these cases was about about this was a registration that is what the title title of the land. It was put to have it was the question of legality of the title. It was claimed, but at the time of registration, at the certificate of the registration, it was about registration in certificate for which may arise subsequent of the title, and the purpose of no was in this case. Once the title was registered, the owner might rest secure without the necessity of waiting of the reply of the court or stating if it was because of to avoid the possibility of losing of the land, the processing of registration of the land was under torrent system. Is a judicial proceeding, but it involved more than consequence than the was in the case of ordinary case of title registration.
Okay, let me further help you, Mr. Madali.
Yes, po.
Can you explain again the principle that registration of land, okay, is not equivalent to ownership?
Principle
Of registration of land is not equal to ownership, as declared in Ricardo versus Saligi. What does that mean?
was because of necessity of uh,
Relax, Mr. Madadi. I just asked whether you're ready for the exam or not. Hindi pa naman exam, recitation pa lang. We still have 2 more meetings, including this one, before the exam. So we're just shooting our topics for probable questions in the exams. Relax.
in this. I think what I understand this case, it was of the security of the title.
Mr. Madadi, may I ask if you understand the question? I will repeat the question. Can you explain to us the principle that registration of land is not equivalent to ownership or does not equate to ownership?
Next week man.
Which is also the principle laid down in Ricardo versus Saligi. Relax, Mr. Madali. Anyway, just let me.
If I understand it, for something, the property maybe not has not been registered. It hasn't. The property has not registered on. Not registered, but the land was. Yeah, has not been registered, but the land was already in the register office.
Sige kuya.
If the land is not registered, has not been registered, but they have a title in the register office. If I'm correct.
We are confused, Mr. Madali. Anyway, thank you, Mr. Madali. Okay, guys, early tip for your exams, no? And for that, because next week is the schedule of your other exams, I think. But as I informed your pupils, we will be holding a belated exam. Okay. Tip number 1. Okay, for every exam, always prepare for question number 1. Okay? Consider always that question number 1 is a shocker. Okay? Always consider that question number 1 is a hurdle. It is your stumbling block. Okay? If you cannot overcome question number 1, you may already be stumped and you may no longer be able to proceed with the other questions. So always prepare that question number 1 is always a shocker. Okay? Be ready. Okay? Prepare yourselves. Yes, Mr. Malali.
Can I try to find a little answer?
Sige.
Can I try to answer? So about your question, sir, that the effect of registration of the certificate of title, it was the registration one in this case to Rene's system and issuance of the certificate of title does not give any owner better title than he had before. So he does not obtain the title by virtue of the certificate. He secured his certificate by virtue of the fact of he has for free. So he has for free and by certificate of virtue, he secured his certificate by title. That for free title, if he obtained the certificate of the title by mistaken to more land, that he really wants to be owned. The certificate should be corrected if he doesn't already have the perfect title. He cannot secure the certificate having a fee simple title and present is sufficient proof of the fact he is entitled to a certificate of registration. The certificate of registration simplified was simply in one document or precise as the correct statement of the exact status of the fees of simple title. Here is the fact as a certificate once issued is the evidence of the title which the owner has the certificate should not be altered or changed or diminished. So except to correct the errors and direct proceeding permitted by law, the title represented by the certificate cannot be changed, altered, modified to diminish or collateral proceeding.
Thank you, Mr. Malali. Mr. Magallanes. Yes, sir. Can you distinguish between a title and certificate of title as discussed in the case of Alde versus Bernal? Bernal. I would like to go back to the certificate of title before. Just open versus Bernal. The certificate of title, I will just try to go back a little bit, sir, as explained that the registration, to clarify, is a document which is a proof that that one has the evidence that he has such title. So in the case of Bernal, Arte versus Bernal. Just try to. Can I check on my file? Okay. Sure, it's allowed. You are forever allowed. Even during the exam, you are allowed. In my exam, huh? I don't care about the other exams. In your exam, in my exam, Be ready with your notes, be ready with your códigos, be ready with your cases, be ready with your books.
So from what I understand in this case, attorney, is that
1,000. Bagong taon na, nag-need pa rin kayo nagpapako.
ay, sir, sorry.
Proceed, Mr. Magallanes.
Wala ako sa focus. From what I understand in this case, sir, is that the real proof of ownership is the title itself. But then again, the registration that is being presented is just a proof that one has a vested right on that said ownership of the said land. So we do not know if, since this is only a registration, the said registration may have some other person who may own it. So, but the person appearing on that certificate, that person has now a greater proof that he owns or has the possession of the said property. So, with the said certificate, it goes to say that the person appearing or the name appearing on the said document would enable the said person to claim or to have more basis to prove that he owns the said property or the said land, sir.
As declared by Justice Johnson in the case of Ricardo versus Sally, the real purpose of the torrent system of land registration is to quiet title to land, okay, and stop forever any question as to its legality. Okay, once a title is registered in the name of a person, okay, the owner may rest secure in himself, okay, without the necessity, okay, of waiting in the portals of the court, or as declared therein in the Mirador to Sukhasa, okay, to avoid the possibility of losing such title. That is the real purpose of Ligarda versus Sality. It is to quiet title to land forever once the title is issued. However, if that is the principle, if that is the rule, according to Ligarda versus Sality, that is the purpose of the torrent system of registration. Mr. Magallanes, why is it that in Aldi versus Bernal, while there has already been an OCT issued, an original certificate of title issued in favor of the Adrianos, okay, the spouses Alde was still declared to be entitled to the property despite issuance and registration of title in the names of the Adrianos.
Oh. I think, sir, that the contention here is that even though there is a certificate, a registration being issued to Bernal, but then the opposition says that he has that he has been in, the petitioners declared that they have been in, I think they have been in open, notorious, and peaceful occupation of the said land, which they have the basis to counter the the registration presented by their by the one who has the registration, sir. Because I think the contention here is that although one has a title, the owners, the perceived owners was they perceive to be themselves the owner of the land because they are in possession. So they have been in that said land for so long in an open open notorious possession of the said land. So they I don't think that they assume, but they believe that they own, they have more right than the person uh, having the said registration or title, sir.
Mr. Mr. Abrasado, Mr. Abrasado,
I think he's absent, sir.
okay. Miss Jimeno,
Sir, Miss Jimeno told me that she can attend class po because she is sick. And she has ano po pala, work po.
he has work.
She has work po, nag-overlap po po yung schedule.
Well, lahat naman tayo may work. Okay, let us see. Mr. Balit,
Good evening, Sir Joey.
yes. I have a certificate of title, okay, covering 173,000 hectares of land. But that title is a Spanish title, okay, bearing from my predecessors in interest, okay.
Yes, sir.
Can I convert that Spanish title into a registered torrents title?
I think no, sir. According to the case of Alde versus Bernal, title is different from certificate of title. So here, if the Spanish title will be converted to Torrens system, then it's a different approach. Since according to the case of Aligarda versus Salibi, uh, the Torrens the Torrens system is basically the quieting of uh, quieting of title of the land. So here uh, they have it has a different approach, or it differs from the title is different from the Torrent system, sir.
Ms. Abonilio, the case of Esteban versus Court of Appeals,
It's okay.
1,000.
The case of Mariano versus, sorry, Esteban versus CA. It is a complaint for recovery of possession of real property and the contents with damages. Um, by the heirs of the late Don Mariano. So they said that they were able to secure titles to the portion of the subject estate, and that they were able to acquire exclusive ownership and possession of certain portions of that subject estate in their names. The Supreme Court ruled on the negative and dismissed the petition for lack of merit. So the Supreme Court said that Titulo de Propiedad number 4136 is declared null and void, and all lands covered by it are excluded from the inventory of the estate of the late Mariano San Pedro y Esteban. So the heirs, agents, privileges, and other or anyone acting for and in behalf of the state of the late Don Mariano are hereby disallowed to exercise any act of possession or ownership or to otherwise dispose of in any manner the whole or any portion of the estate covered by Titulo de Propiedad number 456, and they were ordered to vacate the same.
Why is Titulo de Propiedad 4136 disallowed to cover the properties, or has not been allowed by the court to be used to prove ownership of the lands covered therein?
Yes, because the Spanish titles can no longer be countenanced as indubitable evidence of land ownership. By virtue of Presidential Decree number 892, which took effect on February 16, 1976, the system of registration under the Spanish mortgage law was abolished, and all holders of Spanish titles or grants should have caused their lands covered. They should have registered within 6 months from the date of the effectivity of the said decree, or until August 16, 1976.
Imagine guys, if that case has been allowed to prosper and the Spanish title Titulo de Propiedad 4136 was made to apply. That title covers a vast tract of land, 173,000 hectares to be exact, which covers lands from Nueva Ecija, Region 3, Bulacan, Region 4, Rizal, Laguna, and Quezon, including Metro Manila and down south in Dingalan and Tayabas. That may have already deprived us and your ancestors of the properties that may have been in their possession, similar to the Taliano properties that is being claimed by Prince Michael Taliano. Okay? Ms. Aponilio, can you tell us what is the principle, what is the curtain principle?
One does not need to go behind the certificate of title because it contains all the information.
Under the Burton principle, one does not need to go behind the certificate of title because it contains all the information about the title of its holder. So it dispenses the need of proving ownership by long, complicated documents kept by the registered owner, and they 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 only need to rely on the certificate of title or its title.
Miss Ipingkan, Ipingkan,
So I think she's absent. She's not in this capacity.
okay. Mr. Losada,
Tapos yun ako eh.
Yes.
the case of spouses Ching versus spouses Enrique.
Sorry, sir, I haven't read the case.
Okay. Mr. Lumay,
Yes, sir. Good evening.
the case of Nawaan, Community Rural Bank versus Court of Appeals.
Nawaan. No. Right lah. Hmm. Ay, sus. So, sir, next round lang, sir.
Pardon, Mr. Lumay?
I cannot recall, sir.
Cannot recall. Mr. Losada,
Yes, sir.
if is a person, okay, under the curtain principle, considered in good faith in dealing with property under consideration.
Uh, yes, sir. The buyer should be on good faith, sir.
No.
Because she rely on the face of the title, sir. So it must be in good faith.
Mr. Lumay, let
Sir.
us say, for example, okay, that a certain property X, okay, is being sold by A to B, okay? When presented with a copy of the title, B looking at the title, sees no encumbrances or liens on the property being sold. Upon payment and upon trying to register the parcel of land X, C opposes because he is claiming ownership over the land, as in fact he is in possession of the property X, okay? Claiming open, continuous, exclusive, notorious possession in the concept of an owner even prior to June 12, 1945. Will the curtain principle protect B in his purchase of the property from A?
I think it protects B because according to the facts as I understand, the buyer is in good faith looking at the certificate that there is no some liens and other encumbrances of the certificate of title. Without knowledge that the X has in possession of the property, notorious, and even before 1945, continuous, notorious, and even before 1945.
Ms. Masanke, do you agree?
I do not think so, sir.
Reason?
If I got the facts right, X, X is in continuous possession of the property, but seller A po selling po the property to B because curtain principle promotes or pertains po to the that subject title contains all the details therein. Therefore, prior details or other possessions that pertains to the land may not be contained therein. So I do not think it protects for the buyer.
The case of Alfonso versus Domingo, Ms. Masanke? Ms. Masanke? You're still trying to Are we expecting any answer soon? Miss Masangkik? Kung masyado nang malayo yung hinahagilap mong kaso. You're on mute, Miss Masangkik. Sorry, baka kanina pa. Baka kaya hindi namin, you're on mute pala. Oh.
I believe this is the case of respondent Lilia Domingo who owns a property wherein unknowingly her property was sold to two buyers without their knowledge by a certain Mr. C. So the petitioners spouses Kusi and the other buyer this is the a case for the annulment of certificate of titles issued to the buyers, to which the real owner, Miss Domingo, has no knowledge of the transaction that had occurred between them and the sellers, sir.
Are you trying to tell us or are you trying to pose a question to all of us?
I'm trying to tell, sir.
Okay. Mr. Arellata.
Thank you, sir.
Why are you saying thank you already? Wala pang question. Oh, question. Mr. Arellata, we have learned that property may be acquired through prescription, correct?
Yes, sir.
However, under Section 47 of your PD 1529, it says that no title to registered land in derogation of the title of the registered owner shall be acquired by prescription or adverse possession. Can you tell us why?
I'm sorry, sir. Can you repeat the process? Sorry, sir.
You're trying to process. Okay, we have learned that property may be acquired by prescription, correct?
Yes, sir.
Oh. However, under your Section 47, okay, no title to registered land in derogation of the title of the registered owner shall be acquired by prescription or adverse possession. How can you reconcile that property may be acquired through prescription? However, your particular Section 47 precisely tells us that no title in derogation of the registered title to a registered person may be acquired through prescription.
Sir, if I can remember correctly, when I read this, the provision of PD 59, that specific provision that you referred to is a registered land already registered. A land that is already registered cannot be subject to prescription. So any person thinking that they have claimed such ownership through prescription, but it is registered land, they may not do so. So that's basically the logic behind that provision.
The case of Umbay versus Alecha, Mr. Arellata.
My apologies, sir. It's either I may have found the facts or I have not the case, but as far as doctrine, sir, siguro kahit pa paano, may naalaman naman po.
Okay. Let us see. Miss Midlan?
Good evening, sir.
The case of Jacosalem versus Barangan. Miss Biglan? Baka nakamute ka? Miss Biglan? Nawala si Miss Biglan? Okay, we go back to Miss Biglan. Miss Alfaro,
Yes, sir.
in Umbay versus Alecha, we have learned the principle or the doctrine that the right to recover possession of registered land is imprescriptible because possession thereof is a mere consequence of ownership. Is there an exception to that rule, Ms. Alfaro?
Yes.
Sorry, sir. Can you repeat the question po? Kahit isang beses lang.
Is there an exception to the rule that the right to recover possession of registered land is imprescriptible because possession is a mere consequence of ownership, as we learned in Umbay versus Aleche? Okay? Is there an exception to that rule?
There is an exception to the rule po.
Yes. What's the rule? What's the exception, Ms. Faro?
Oh, sayop eh.
Ms. Alfaro, bakit biglang lahat biglang lahat namumute?
The exception po to the rule is that um, um, if the land is acquired po through adverse possession.
Can you explain, Ms. Alfaro, how is that an exception?
Since they cannot acquire the property when it due to a claim of, let's say, an acquisitive prescription, then in case of an adverse possession, since there is no or one of the exception to the rule is if there is no title to the registered land and afterwards the owner of the land was able to acquire through adverse possession.
Mr. Kababan, Mr. Kababan, Mr. Haban,
Yes, sir.
the case of Pangasinan versus Almazora,
Pangasinan versus
Almazora, sir.
Yes.
In the case of Pangasinan versus Almazora, sir, this is the facts of the case, sir. In Pangasinan's predecessor in interest, learned that the title of the subject property of this case was transferred to the year of his predecessor in interest. The title had long been transferred in the name of Conrado, and that the subject property had been sold to a corporation by the years of Conrado. Aurora asserted, sir, that through the years, she repeatedly asked Conrado to return the owner's copy of the title. However, due to procrastination, it was not given until he died. Aurora repeatedly asked Christina for the title of the copy. However, the request was also ignored, and so the subsequent sale of the property in full way accordingly was without the authorization of Aurora, and the payment received by the respondents for the sale of the property should be returned to her, and that she prayed for damages. The respondents, however, countered that the property was already, and it was properly transferred to Conrado, and they averred that there was no fraud in the registration of the property.
To cut the story short, Mr. Naba, okay?
Yes,
What
sir.
to learn as a doctrine in the case of Pangasinan versus Almazora?
The doctrine of Blanchester apply as an exception to the rule that no prescription should set in the in the action for the recovery of a registered property, sir.
Can you give us a distinction between lashes and prescription as declared in Pangasinan versus Almazora?
Lanchester is the failure of the owner of the right to assert his right for an unreasonable and unexpended length of time. That's Lanchester. So you do not impose your right for an unreasonable length of time. In prescription, prescription is prescription. For a length of time, sir. For a length of time, because of a length of time, you acquire the ownership to a property. If I may describe it that way, sir.
Miss Teresa's spouses appointees versus O.
the facts of the case, a parcel of land located in Kabankalan, Mandalo City, initially registered under the name of Roberto Aboitiz. This parcel of land originally belonged to the late Mariano Senyo. On July 31, 1973, Mariano executed a deed of absolute sale in favor of his son, Ciriaco Senyo. On May 5, 1978, Ciriaco sold the two lots to Victoria Co. The parties executed a deed of absolute sale, and on July 15, 1982, Mariano died and was survived by his 5 children. In 1990, Peter Poe discovered that Ciriaco had executed a quit claim dated August 7, 1989, renouncing his interest in favor of Roberto. In the quit claim, Ciriaco stated that he was declared owner of lots number 4 of the two lots. The spouses co confronted Ciriaco by way of remedy. Ciriaco and spouses co executed memorandums of agreement dated June 28, 1990. The Ciriaco agreed to pay Peter the difference between the amount paid as consideration for the entire property and the value of the land the spouses co were left after the claim. However, also in the 1990, lot number 2, the Mariano heirs, including Ciriaco, executed separate deeds of absolute sale in favor of Roberto. Thereafter, Roberto immediately developed the land as part of the subdivision called North Town Homes. Then Roberto filed an application for original registration, which the trial court granted, issuing him the OCD in the name of Roberto. The land was immediately subdivided and parcels sold for investment.
Mababa?
Yung sa cases po, sir, sa facts of the case na.
So, in short,
So the doctrine,
bakit nag-e-echo ako? Bakit umay? Hello?
yes, sir.
Is there an open other circuit there?
Nakalagay po nakakonect po sa speaker, so I can hear you.
So pakipatay para hindi tayo nag-feedback at saka nag-e-echo. Okay. So, what doctrine do we learn from this case of spouses Aboitiz versus spouses po? Miss Teresas.
The document is about the reconveyance, sir, or the annulment of titles. A complaint for reconveyance is an action which admits the registration of title of another party, but claims that such registration was erroneous or wrongful. It seeks a transfer of title to the rightful and legal owner or to the party who has a superior right over it, without prejudice to innocent purchases in good faith. And it seeks a transfer of title issued in a valid proceeding. An action for annulment of title questions the validity of the title because of the lack of due process of law. There is an allegation of nullity in the procedure and thus the invalidity of the title that is issued.
Can you give us a distinction between laches and prescription as described in this case of spouses Aboitiz versus po?
Laches and prescription, sir. As in the previous case, sir, it was defined the laches are the negligence on the part of the owner to fight for his right over the title, over the ownership. And prescription, it is the lapse of time, wherein the lapse of time wherein he lost the opportunity to the lapse of time where the ownership was lost due to the laches.
Mr. Caimbon?
Yes, sir. Good evening po.
Is the principle of estoppel by laches, as we learned from Mumbai, appointees, okay, applicable, may be applied against the government or the state for that matter.
No, sir. Based on my reading, sir, the government or the state is not covered by stopped by nudges.
Why?
Um,
Remember, guys, in your exam, ALAC, answer, legal basis, analysis, conclusion. So yung legal basis, analysis, and conclusion, yun yung nandun nakapaloob, doon yung why. Usually yun yung pinapractice natin sa recitation.
yes, sir.
Hmm.
With regard to the applicability of estoppel against the state, as a general rule, the state cannot be put in estoppel by mistake or errors. However, estoppel against the public are little favored. They should not be invoked except in rare and unusual circumstances, and may not be invoked where they were operate to defeat the effective operation of a policy adopted to protect the public. They must be applied with circumspection and should be applied only in those special cases where the interest of justice clearly require it.
Mr. Kekega, Mr. Kekega, is Mr. Kekega around?
Sir, I think he's absent or he's not in the Zoom.
Yes, okay. Miss Kitlong, since you Miss Kitlong, the case of Republic versus Court of Appeals, January 21, 1999.
Lot.
The case of Republic versus Court of Appeals. In this case, St. Jude Enterprises Inc., which is the registered owner of a lot, subdivided the lot and caused the Register of Deeds of Caloocan issued certificates of titles in their name. However, the subdivision of the lot was later found to have expanded, and then this was confirmed by the Land Registration Commission, and then St. Jude sold the lots to various buyers. So in this case, Solicitor General filed an action seeking the annulment and cancellation of the said certificate of title, principally on the ground that these were issued on the strength of a null and void subdivision plan, because the subdivision lots were expanded from the original area. So in this case, the trial court actually dismissed the complaint of in that the Solicitor General failed to present proof that St. Jude had committed fraud when it submitted the subdivision plan. And the court concluded that the government was already in instapel to question the approved subdivision plan because it allowed and approved the said plan.
Miss Kit,
Yes,
may I cut you short there?
yes, po.
You're saying that the case of Republic versus Court of Appeals says that the principle of estoppel by lashes applies even to the government, correct?
Yes, yes, po.
How would you now reconcile that with the contention of Mr. Caimbon that estoppel by lashes does not apply to the government?
It's that the contention of Mr. Penbon is actually the general rule. So the general rule is that state cannot be put in estoppel by the mistake or error of its officials or agents. However, this has an exception. So that exception is what the Republic versus CA is talking about. Or what that exception is the exception that is being talked about in the Republic versus CA.
May I correct you there for the information of the class? Okay, the general rule is that prescription, okay, prescription does not lie, okay, to registered land. That is the general rule. The exception is estoppel by lashes. Exception to the exception is that estoppel by lashes will not apply to the government. An exception to the exception to the exception. Okay? Don't be confused with the use of Ms. Kitlong that it is a general rule with regard to the government. It is already an exception to the exception. Okay? But a further exception to the exception, okay, is found in Republic versus Court of Appeals where the government may be considered to be in estoppel. Okay? And only in those instances as provided under your Republic versus Court of Appeals, as opposed to and as distinguished from the probable case, one of the probable cases that Mr. Caimbon is probably thinking of, which is your case of Republic versus Marcos, as stated in your textbooks. Okay? So don't be confused. So those are your exception to the exception to the exception. Got that? Don't be confused. Miss Tabarda,
Confused na nga eh.
Good evening, sir.
can you give us, okay, why title to registered land cannot be or shall not be subject to any collateral attack?
Yes, sir, because it's stated in the land registration that once a certificate of title or once it's registered under the torrent system, it is an evidence of an indefeasible title to the property in favor of the person whose name appears on the title.
Can you distinguish between a direct and collateral attack, Mr. Borda?
When we say direct attack, it is attacked by the when you say, sir, direct attack, it is when the object of the action is to annul or set aside a judgment or to enjoin its enforcement. While collateral attack, it is when the action is to obtain a different relief or an attack on the judgment or proceeding is made as an incident thereof.
Verboso versus Court of Appeals, Mr. Borda.
Hermoso. Sorry, sir. Ano po that?
Verboso. Melencio Verboso versus Court of Appeals.
Verboso po. Verboso. So this is a case, sir. It is a petition for review of the decision involving the confirmation of the order of conversion and the determination of the amount of disturbance compensation filed with the RAB by Belen and Corazon Carlos. So the private respondents here, Belen and Corazon Carlos, filed with the Bureau of Land Acquisition, Bureau of Land Acquisition, Distribution, yung DARAB, sir, joint request for the conversion of their parcel of land consisting of 48 hectares located or situated at Iba, Kamalig, and Calvario, so in Bulacan. So there were issued certificates of
I will
title.
short Mr. Borda, because apparently, again, we are still in that practice of our previous judges that we are trying to eliminate, okay, from you with pertaining only to my class, okay, with regard only to my class. But it seems that all of you are still on that habit of your old kind of digest. Anyway, Mr. Borda, in Verboso versus Court of Appeals, what kind of an attack was made on the title involved in such a case?
It's a direct attack, sir. So there's an occasion to here in this case, there's an occasion to discuss the issue of direct attack on the validity of titles. So we say when a torrent's title, as a rule, it is conclusive and indefeasible. So based on PT or Presidential Decree 1529, Section 48 provides that a certificate of title shall not be subject to collateral attack and cannot be altered, modified, or cancelled except in a direct proceeding. So so the question here is when is an attack, an action on attack on a title? So it is when the object of the action or proceeding is to nullify the title, and thus challenge the judgment pursuant to which the title was decreed. So as mentioned earlier, so the attack is direct when it is the object of an action or proceeding to annul or set aside such judgment. So on the other hand, the attack is indirect or collateral when an action to obtain a different relief on attack or on the judgment is nevertheless made an incident thereof.
Thank you, Ms. Tan. Sharmi? Ms. Kitlong, she has not been attending.
Yes, yes, sir. She already dropped. However, when I asked for the confirmation from her drop so that I can send it to you, she didn't send anything.
Mr. Vallejo? Thank you, Ms. Kitlong. Vallejo? Mr. Ribar? Can you give us examples of actions that are not considered as collateral attacks on title to land?
Since there are direct collateral attacks, example, sir, I think question of validity, question of validity in the annotation of the title, sir.
Pardon?
Example on the collateral attack, sir, is again on the
Answer the question. Yes. Which are not considered collateral attack.
Okay.
Not considered. Yan. Sagot kayo ng sagot. Hindi nyo muna intindihin tanong. Mayayari kayo sa exam.
Yo.
In order to help you, Mr. Bibar, let us give an example. Apostol versus Court of Appeals. Is that a collateral or a direct attack?
Collateral attack, sir.
Why?
Sir, they are not questioning the title itself.
So,
When you question the validity of the title itself, it is an direct attack, sir. However, if the otherwise, sir, it is collateral. If you are not attacking the validity of the title itself, it is collateral, sir.
how precisely our question? According to you, is the attack made on Apostol a collateral attack and not a direct attack? How? The doctrine is there. That is why we are trying to ask you of the doctrines. How is it that it is such as declared by the court?
Direct attack.
So, sir, certificate of title shall not be subject to collateral attack.
Mr. Villaseran? Let us say, for example, Mr. Villaseran, tatlo nga pala, dalawa nga pala kayo. Victor Jan. Yes, Gravy. Let us say, for example, okay, when they filed a case in court for quieting of title against B, claiming that his title A is earlier issued than A, than B's
Direct
title.
attack.
Okay? Is that a collateral or a direct attack?
Direct.
It's a direct attack. It is a direct attack. Why?
Because when A filed a case for quiet title, he asserted that um, that the possession of B of such title must be annulled or it must be declared by the court null and void. Because the object here is the title itself of what A was praying for was the title itself. The contention of A is the title itself. So it is a direct attack because A prayed for nullifying this possession or ownership with regards to the title or land.
The case of Vicente versus Avera, Mr. Victor John.
Avera, sir.
Vicente versus Avera.
So, Provencio Rebuquiao executed a deed of sale, absolute sale in favor of Vicentes. So, what happened was the respondent, Dalia Soledad, alleges that Rebuquiao granted to him by Ovencio a special power of attorney to sell the land. So
Surrender na lang niya.
the transfer certificate
Surrender na lang. Klaro kayo mga ka nagbasa.
The deal of absolute sale was cancelled. I'm sorry, sir, because I just saw this case. I'm just trying.
Okay. Yeah, okay. Mr. Di Marukot.
Yes, sir. Good evening po.
Yes, good evening. The general rule is that, okay, under Section 48, a certificate of title cannot be attacked or shall not be subject to a collateral attack. It cannot be altered, it cannot be modified, it cannot be cancelled except in a direct proceeding in accordance with law. Is there an exemption? Section 48.
Sir, from our answer, there's no exception from the prohibition of a collateral attack in PD 1529 for the issued title.
Under the cases of Berboso and Lakbayan, how is a direct attack or an attack is defined, Mr. Di Marukot, against a title? How is an attack or a direct attack against a title is defined?
A direct attack has been defined as something or if the petition is directly or
Nullifying the
substantially
title.
questioning the issuance of the decree of the title to a person. And the collateral attack is defined, while the collateral attack was defined as
situation that is, or if a person is praying for something that is not directly in relation to the issuance of the degree of the title, but just a subsequent action, or like indirectly questioning the issuance of the title.
Mr. Ebe, the case of the Guzman versus Agbagala. Bakit bigla kang nagsarado ng pinto? Wala nang nagawa kang kalokohan dyan, ah.
Hindi ko yung alam ko pumasok.
Oh.
The case of the Guzman versus Apagalo. Closing offer as the collateral document, which turned out to be a deed of donation, purportedly signed by Carmen in favor of their niece, manager, Javier Cruz, daughter of Juana and sister-in-law of There is funded 5 case against Madeline, weighing that the deed of donation being ratified.
Is that coming from, excuse me, Mr. Ebe, is that coming from you? Parang may radio something ba? Palayo yung isang phone. Para hindi obvious na palayo yung isang phone.
Yung headset lang po siguro.
Okay.
The RTC declared the deed of donation in favor of Madeline, null and void ab initio, cancelled the deeds of sale executed by Madeline in favor of the defendants. In the review of degree of registration, innocent purchaser forgot. The degree of registration shall not be reopened or revised by reason of absence, minority, or other disability of any person adversely affected thereby, nor by any proceeding in any court or reversing judgment. Moreover, to the right of any person, including the government and branches, deprived of land or of any estate of interest therein by such application of confirmation of title obtained by actual fraud, to file in proper court a petition for reopening and review of the decree of registration. But later than
Again, Mr. Ebe, I know you have already done your digest. Okay, so, in short, is Agbagala. What lesson do we learn or what doctrine do we learn from Agbagala?
In this case, the certificate is not subject to collateral analysis.
By
It's based upon the expiration of say period of 1 year, the degree of registration and the certificate of title issued shall become incontrovertible.
Mr. Villaseran, Juan Miguel, do you agree?
Hello, sir. Hello.
Do you agree with Mr. Ebe?
Sir, galing po kasi ako sa CR. So, I was, that's why I turned off my camera. Sorry.
Okay. Moving forward, let us say, for example, X, okay, acquired a parcel of land in a foreclosure sale. Okay? After inspection by X, he noticed or he knew that there is an occupant on the subject property. Okay? Therefore, X filed an ejectment suit, okay, against the possessor or the occupant. The occupant filed a counterclaim against X, asserting ownership of the land. Is the counterclaim filed by the occupant of the land considered collateral or non-collateral attack on the title?
Sir, the claim of the petition is it is a direct attack, sir.
Why?
Because titles cannot be attacked. Titles cannot be attacked indirectly. It should be attacked directly. The core issue of the cancellation, is it cancellation, sir, or ejectment? Ejectment, sir.
Annulment.
The core issue is the ejectment, sir.
Mr. Caronan, do you agree with Mr. Ebe?
About the sir,
that Bagala teaches us that attack therein is a collateral attack.
I'm sorry, sir. I haven't read this case book.
The case of Development Bank of the Philippines versus Court of Appeals, Mr. Caronan.
Okay. In Development Bank of the Philippines versus Court of the Appeals, the court found no obstacle to the determination of the validity of the TCD in a counterclaim. Speaking through Justice Mendoza, the High Court said, it is true that the indivisibility of Torres title cannot be collaterally attacked in the instant case. The original complaint is for recovery of possession filed by petitioner against private respondent, not an original action filed by the latter to question the validity of the TCD, on which the petitioner bases its rights. To rule on this issue of validity in the case of the recovery of possession is tantamount to a collateral attack. However, it should not be overlooked that private respondent filed a counterclaim against the petitioner, claiming ownership over the land and seeking damages. Hence, the court ruled on the question of the validity of the DCT for the counterclaim can be considered a direct attack on the same. So they said a counterclaim is considered a complaint only this time it is the original defendant who becomes the plaintiff. It stands on the same footing and is to be tested by the same rules, as if it were independent action.
Yes, Doctor.
So,
Subukan natin. Okay? Bar question. Okay, bar question. Total, malapit na mag-exam. Can you give us the principle of primus tempore potior ure? Mind you, that is the exact question in the Kagiwa Bar in civil law.
Sir, principle of primus inter pure.
Ako. Baka nasa isip mo is yung primus inter pares, Miss Doktor, iba yun. Primus tempore potior ure. Okay, to help you, Miss Doctor, the case of Rosaroso versus Soria, please.
In this case, sir, the principle of primus tempore potior or first in time, stronger in right, wherein when the thing sold twice is immovable, then the one who acquires it and first records it in the register of property, both made in good faith shall within the owner. Then the registrant must have no knowledge of the defect or lack of title of his vendor or must not have been aware of fact, which should have put him upon such inquiry and investigation. Also, the general rule is that the purchaser may be considered a purchaser in good faith when he has examined the latest certificate of title. Then, exception to this rule is when there exists important facts that would create suspicion in an otherwise reasonable to go beyond the present title and to investigate those that preceded it.
Miss Carion?
Yes, sir.
Can you explain to us the rationale of the requirement of good faith? Okay? In Articles 1544, in the case of Uraca versus Court of Appeals, the case of Rosaroso versus Soria, espousing the principle of primus tempore potior ure.
Oh my God. That's a lot. Okay.
No, I just cited the different cases.
Either of them.
But the question is, what is the rationale of good faith for the requirement of good faith in all those cases? See? Guys, read or listen to the question first, kaya kayo na-overwhelmed. Simple lang yung question. What is the rationale? Sinite ko lang yung other cases.
Give me a moment, sir.
Oo, lahat naman kayo, binigyan ko kayo ng moment eh.
That is very true. You are very fair.
Okay. The principle of primus tempore, for your juror, first time
For sure,
is,
Uri.
sorry,
Sabi nila, sabi ng mga nakatatanda sa akin, that's how you pronounce it daw.
for sure,
Especially your author, okay, Justice Agkawili, corrects us. Okay? It is primus tempore, posure ure. That's how you pronounce it daw. Sabi ni
primus
Justice
tempore, for sure, jure.
Hore.
Ure, sorry, for sure, ure. I stand to be corrected. Thank you, sir. First in time, stronger in right. Gains greater significance in case of a double sale of immovable property. When the thing sold twice is immovable, the one who acquires it and first records it to the registry of property, both made in good faith, shall be deemed the owner. Verily, the act of registration must be coupled with good faith. That is, the registrant must have no knowledge of the defect or lack of title of his vendor, or must not have been aware of the facts which should have put him upon such inquiry and investigation as might be necessary to acquaint him with the defects in the title of his vendor.
Miss Fernando,
Good evening, Sir Joe.
can you distinguish the difference between the written principle and the mirror doctrine?
So for the written principle, here the Tolerant of ownership can be challenged in any court for civil or criminal. But for the mirror doctrine po, here there are exceptions, which for the mirror doctrine,
Miss Fernando, nawala ka na? Humina rin ba yung internet? Miss Fernando, are you still around? We move forward, Mr. Guevara.
Sir, connecting daw po si Sir Rivera. Sir Joey, nawala po yung connection. Sorry po.
Oo nga, buti na tayo. Si Mr. Guevara eh.
Wala po.
Okay, you try to give me, wait lang, give me a minute or so. Okay, are we back live? Miss Hernandez, Miss Fernando, you were saying a while ago.
Yes, sir.
Oh,
Sir, for the mirror doctrine, here, here all the person dealing with the property covered with the torrent certificate title are not required to go beyond what appears on the exact title po. Well, the 14 principle po, for the 14 principle, for the 14 principle po at Sir Joey, for the 14 principle, ito po. For the 14 principle po, one does not need to go behind the certificates of the title because it contains po all the information about the title of the holder.
Mr. Guevara, are you already connected?
Yes, sir. Good evening, sir.
Yes, Mr. Guevara. We mentioned previously, or we asked about the case on the 13th principle, which applies to your principle of primus tempore posteriore. Does that admit of an exemption?
No, attorney. Sir.
Tama ba ang tinig ko?
Yes, sir.
Two in a row ba si Mr. Guevara?
Yes lang, sir.
Pinait si Mr. Magallanes, Oh, Mr. Guevara, there is none, according to you. Why?
Because there is an exception, sir.
Oh, ang bilis mo naman magbago, porque naka-2,000 ka lang. Balik agad. Nagising ka bigla, no? Kasi babayad ka 2,000 eh. Oh, ano ba talaga? Meron or wala? There is or there is none? Make up your mind.
There is an exception of the sir in a bad faith.
Can you explain?
Toro.
As the general rule, sir, is that purchaser be considered a purchaser in good faith when he has examined the certificate of title.
Ms. Cortez,
Yes, sir.
according to the case of Nawaan Community Rural Bank, who is an innocent purchaser for value?
Sir, Nawaan versus
Nawaan Community Rural Bank versus Court of Appeals.
Sir, as I remember, an innocent purchaser, sir, is someone who doesn't know that the vendor, that the title of the certificate of the title of the vendor has no actual knowledge or of the defect of his or her title.
What is the rationale behind the rule, the doctrine of innocent purchaser for value?
Sir, he or she is honest in doing business, in buying the property.
Continue.
Um, sorry, but it's okay, sorry.
Okay, guys, if you will notice, if you will look at our outline as well as you will look at your syllabus, you will notice that we are looking at almost the same cases, correct? Your nawaan is under your curtain principle. Your nawaan is under your good faith. Your nawaan is under your collateral attack. Okay, your your Secretary of Environment versus Yap is is it may be found in your Torrent certificate of title. It may be have been discussed somewhere else prior to in items 1, 2, and 3. Okay, why are these no? Because you will notice that as we have explained a while ago with Ms. Kiplo, okay, there are general rules with regard to your proceedings in land registration proceedings. Okay, remember your very first, okay, general rule is that your recalliant doctrine. Okay, all lands of the public domain belong to the state. Okay, all lands of the public domain. What is the exception? That those that are not alienable and disposable, those that are not non-registrable properties of the state. Okay. We further discussed whether prescription lies or whether prescription lies against the registered title. The general rule cannot. Okay? But there is a corollary rule that prescription is a mode of acquiring ownership. What's the difference? Because one, there is already title, okay, issued by the state to a person, thereby granting him ownership thereof. And once title has been registered and once title has been proved and once ownership has been proved, prescription does not lie, okay, against such title or such ownership. What is the exception to prescription? Your latches. When lapse of time, even though you have the right, okay, even though one has a right, either to eject a claimant or to prove his certificate or to prove his ownership over the land, but he slept on his rights. Okay? While prescription does not lie against certain as a title owner, because the one who has the right failed to assert such right after a period of time, after a lapse of a period of time. Okay, your cases range from 15, 20, 36, 50 years. Therefore, when one sleeps on his right, the principle of estoppel by lashes may set in as against the general principle of prescription. Okay. Your primus tempore cusuriore states that if there are two properties, okay, sold or disposed of or conveyed, one who asserts or one who has an earlier title has a stronger right. That only is a general rule if there is good faith. If there is bad faith, okay, if there is bad faith, if one is considered not an innocent purchaser for value, going against the principle of the curtain principle, going against the rational of the curtain principle, okay, therefore he is by virtue of constructive notice, okay, he must be put on guard to verify the validity or the strength of the person selling, conveying title to the property involved. If he did not exercise such diligence, okay, under your related principles, he will not be considered an innocent purchaser for value, even though he may have been issued another title thereto, or he may have paid valuable consideration therefore, he will still be barred by virtue of the mirror doctrine that a person must exercise. Okay? A person must exercise every diligence required when there is notice, when he has been put in notice that there may have been a defect in the title of the person conveying such property to him. Okay? You will note in those cases, paulit-ulit lang yung mga cases because they discuss or they point out to us how is the general rule applied and how are the exceptions applied. That is why we are trying to again tell you, or we are trying to put you in practice of getting the doctrines and the application of the doctrines in those cases in digesting your thesis. Remember, we are. That is why I am trying to emphasize that in my class for our purposes, we forgo the immaterial facts, the non-relevant facts. We just deal with what is the very nature or what are the very essential facts with regard to a particular case. Because we are more concerned with the doctrine, how they are applied in those particular cases. Okay? So for the next meeting, guys, 5 and 6, remedies and subsequent billing in registered land. Okay, you will please take a look at the cases. You will notice that those cases, while there may be a lot, it may overwhelm you, but those cases pertain to the several remedies available to aggrieved parties in registration cases. This involve these cases involve basically your direct attack on the titles to the property. Okay? So for that, good night, Miss Villaluz and Miss Kitlong. Please take note of our retainers fees and collections for the night. Okay? Good luck for your other classes and good luck on your exams for next week.
Thank you, sir.
Thank you,
Sir
Joey.
Joey.
Sir Joey.
Thank you, Sir Joey.
Nice classmates.
Classmates, if I may just make a special request, especially for those who know that their digests do not, follow the instructions of Sir Joey. Kindly, we still have time to revise and, kasi some of us really, exerted effort to come up with the required digest, whereas, sadly, or sad to say, some of the digests do not conform with the requirements. So may I just make a very special request to those, you know who you are, to those who have, quite a long digest po. Para, syempre, hindi naman po tayo matatawag sa digest natin. So, sana para po maiwasan natin yung galit tayo ni Sir Joey. Thank you.
Good night.
Thank you, Mamina. Good night po.
Hi.
Good luck next week.
Absent ako.
Tapos na ako, pwede na akong ma-absent.
Yes, grandma. Ang tawag ko sa lola ko, Losh. Taxi tayo. Bye.